Hi, welcome to our channel of IGNOU Audiobooks, Indira Gandhi National Open University, School of Journalism and New Media Studies, SOJNMS. Bachelor of Arts, Journalism and Digital Media, BAFJDM. Semester 3, Block-1 Ethics and Regulations. Unit-2 Indian Constitution and Media, 2.0 Introduction. In the previous unit, we explored the Constitution of India, which stands as the supreme law of the land, and examined its essential features. Remarkably, it is among the longest constitutions globally, consisting of 395 articles, 12 schedules, and around 100 amendments. For media professionals and organizations, especially in today's digital age, the most relevant constitutional provisions are Articles 19, 1, 19, 2, and 361A. Article 19, 1, ensures the fundamental right to freedom of speech and expression, a principle that has become increasingly vital with the advent of digital media and online journalism. Article 19, 2, permits the state to impose reasonable restrictions on this freedom to protect interests such as sovereignty, security, public order, decency, morality, contempt of court, defamation, and incitement to an offense, thereby ensuring that digital content meets legal and ethical standards. Article 361A offers protection for the publication of legislative proceedings, allowing media, including online platforms, to report on parliamentary activities without fear of legal repercussions, provided the reports are accurate and not malicious. In this unit, we will examine various laws and significant constitutional. According to Durga Das Basu, former judge and eminent legal luminary, freedom of press today means absence of interference by the state with the press, except insofar as it is authorized by the Constitution of India and by laws which are constitutionally valid. While normally freedom of the press means freedom to write, print and publish whatever one likes, anywhere, anytime, the fact is that in normal circumstances it is seldom possible or permitted for any media person or organization to be able to function to their fullest potential to a meaningful, purposeful and satisfying scale. A full, total and complete freedom of speech and expression is a matter of necessity. While the print media operate and express themselves through printed words at regular intervals, audiovisual media use words and images to present their programs and express themselves. The print media have some kind of inbuilt permanency in their operations. Audio and visual media generally lack those characteristics. Therefore, separate laws have been enacted for print and electronic media. 2.2.1 Press Freedom, Historical Overview. One of the strongest reasons for the freedom of the press was given by John Milton, 1608 to 1674, in his Areopagitica, 1644. According to him, let truth and falsehood grapple together in an open arena, and ultimately the truth shall prevail. The second most important philosophy for freedom of the press was given by John Stuart Mill, 1806 to 1873, in his essay on Liberty, 1859. He said, if all mankind minus one were of one opinion and only one person were to be of contrary opinion, mankind would be no more justified in silencing that one person than he, if he had the power, would be justified in silencing the mankind. In the USA, immediately after independence of the country, the freedom of press was acknowledged to be a vital part of the American Bill of Rights in 1791. The United Nations Universal Declaration of Human Rights has also recognized the freedom of press as a basic human right. In India, freedom of the press has had a checkered history. In 1776, when William Bowles expressed his intention to start a newspaper, he was deported from India. When India's first newspaper, the Calcutta General Advertiser, also known as the Bengal Gazette, came into existence in 1780, during the regime of the East India Company, its editor, James Augustus Hickey, an employee of the company, had to pay through his nose for exercising his press freedom. Whenever his weekly published some adverse story about the East India Company, he was taken to task. Ultimately, he was asked to stop the publication and was deported to England. Later, in 1799, some rules were issued requiring newspapers to submit to pre-censorship of the material for publication. Thereafter many regulations came into being in the years 1823, 1835 and 1857, 1878, 1908, 1910, etc. Indian Penal Code (IPC) was enacted in 1960. Recently, the Government of India has introduced Bharatiya Nyay Sanhita (BNS) in place of IPC. This unit gives relevant updates of the respective IPCs with the provisions of BNS. About the freedom of the press. The reason is that the words speech and expression include the freedom of press. All sorts of writings in the press, viz. newspapers, magazines, journals, books, etc., include expression in writing of ideas, stating views, airing opinions, uttering or communicating thinking on a given subject, issue, problem or a proposition. 2.2.3 Limit of press freedom. The fundamental right of speech and expression, which include freedom of the press, is not absolute. Therefore, reasonableness of a restriction can be decided only on a case-to-case basis. However, no restriction on freedom of speech and expression can be imposed on any other ground except the 8 grounds mentioned above. In the Sakal Papers case in 1962, the Supreme Court decided that the government could not impose a restriction which would directly affect the volume of a newspaper circulation or limit the number of its subscribers or reduce its size. In the case of the Ministry of I&B, Government of India vs. Cricket Association of Bengal in 1995, the Supreme Court decided that reasonableness of the restriction should be viewed from the right of viewer and listeners, not from the right of broadcasters. Financial, political, and social interests of the owners of media also adversely affect media freedom. Terrorists also try to impose a ban on media freedom. 2. Control these enemies of press freedom. Article 19, 1a, is helpless. During terrorism in Punjab, 1984 to 1995, 2 proprietor editors of the Hindi daily Punjab Kesari were killed by terrorists. In June 2018, Rising Kashmir editor and his 2 bodyguards were killed in Kashmir by terrorists. 2.3 Law of defamation. Newspaper correspondents and reporters are often assigned to cover functions where well-known persons and political leaders are invited to speak. While writing their news stories, media persons have to quote them in their day-to-day journalistic assignments and they are expected to report truthfully, accurately, and objectively. However, at times, some of them may be tempted to write casting aspersions on the speaker's or interviewee's professional standing, individual life or private matters. Or, when broadcasters air news items, they may intentionally or otherwise put some remarks that may be seen as unbefitting. Therefore, when such writings appear in the media, these are prone to lower the image, reputation and status of the leaders in the general estimation of the audience, amounting to libel or defamation. 2.3.1 Definition and kinds of defamation. Defamation can be simply defined as a false attack on someone's reputation that supports a claim of loss of someone's good name leading to humiliation, disgrace, shame, ridicule, mental suffering, embarrassment, or exposure to public hatred. Defamation is of 2 kinds, verbal and written. Verbal defamation is called slander, whereas written defamation is called libel. Both offenses are punishable under the same provision of the BNS, earlier it was IPC. Defamation can be civil or criminal. Civil defamation is not codified in India. It is based on English common law, subject to statutory exceptions. Criminal law of defamation has been dealt with very exhaustively under sections 499 to 502 of the IPC. The definition of defamation, previously covered under section 499 of the IPC, is now encapsulated in section 356, 1, of the Bharatiya Nyay Sanhita, BNS. The BNS reduces the total number of sections from 511 in the IPC to 356. Intention is irrelevant in civil law of defamation. Truth of the statement is complete defense in civil cases. However, in criminal law, bad intention is essential for liability, and truth as such is no defense except in the first exception. To Section 499, the relevant sections of the Bharatiya Nyay Sanhita, BNS 2023 corresponding to the IPC Section 499, defamation, are Section 354, 1 and 354, 2. In the BNS, earlier it was IPC, defamation has been defined as whoever by words, either spoken or intended to be read, or by signs or by visible representations, makes or publishes any imputation concerning any person intending to harm, or knowing or having reason to believe that such imputation will harm the reputation of such person, is, except in the cases hereinafter accepted, to defame that person. A. It may amount to defamation to impute anything to a deceased person, if the imputation would harm the reputation of that person if living, and is intended to be hurtful to the feelings of his family or other near relatives. B. It may amount to defamation to make an imputation concerning a company or an association or collection of persons as such. C. It may amount to defamation if an imputation in the form of an alternative or expressed ironically is published or broadcast. D. No imputation is said to harm a person's reputation, unless that imputation, directly or indirectly, in the estimation of others, lowers the moral or intellectual character of that person or lowers character of that person in respect of his caste or of his calling, or lowers the credit of that person, or causes it to be believed that the body of that person is in a loathsome state, or in a state generally considered as disgraceful. The BNS also provides for some exceptions. It will not amount to defamation of any person. 1. If it is a true imputation, and is in public good, that imputation should be made or published, but whether or not it is in public good is a question of fact. 2. If an opinion has been made in good faith on the conduct of a public servant in the discharge of his public functions, or his character, so far as his character appears in that conduct. 3. If an opinion has been made in good faith on the conduct of any person touching any public question, and his character, so far as his character appears in that conduct. 4. If a publication has been made which is a substantially true report of the court's proceedings, or the results of any such proceedings. 5. If an opinion has been made in good faith on the merit of any court decision, or in respect of the conduct or character of any person relating to that case. 6. If an opinion has been made in good faith on the merits of any musical or theatrical performance or a book which has been offered or submitted for review or critique or scrutiny. Reviews in newspapers, magazines, critiques of artistic works are not deemed defamation. 7. If a person having an authority over another person, either by law or any lawful contract, passes a censure on the conduct of that person. For example, writing confidential reports of subordinates, teachers' reports on students, etc. 2.3.2 Punishment for defamation. The law of defamation provides that if a person is proved to have committed an act of defamation, he will be punished with simple imprisonment for a term which may extend to 2 years, or with a fine, or with both. However, the courts reserve the right on awarding such punishments depending upon the gravity of the infringement of law. The law also provides that if a person or an organization is found to be selling or offering to sell any printed material containing defamatory matter, knowing that it contains such matter, shall be punished with simple imprisonment for a term which may extend to 2 years, or with fine, or with both. With the introduction of BNS, which provides modern approaches to the punishment as well as it gives scope of alternate ways of sentencing. 2.4 Journalistic defenses under law of defamation. Given below are some of the legally permitted journalistic defenses that could absolve a media person of any charges of defamation that may have been brought against him, her by an aggrieved party. Fair comment. Fair comment on any matter of public interest does not amount to defamation. Privilege. There are occasions when it will not amount to defamation if the report published is in public interest. It is considered privilege in public interest. Privilege is of 2 types, absolute and qualified. Statements made by judges, witnesses, advocates and parties are qualified privileges. The statements made on the floor of a house of legislature in India are examples of absolute Privilege. Truth and justification. In criminal prosecutions for defamation, mere truth is. 4. Maximum punishment provided in Section 3 is 14 years. The other relates to unauthorized communication of any secret official code, password, sketch, plan, model, article, note, document or information. Section 5. The punishment for this is up to 3 years or fine or both. Section 5 of the Act is more important for journalists. It prescribes punishment for a person who voluntarily receives or communicates any official secret. However, the Act does not define official secrets. Therefore, any information which authorities consider as secret can be published only with the pain of punishment. The government normally has an administrative culture of secrecy. The Act also prescribes that it would be the duty of all citizens to provide any information they may have about the breach of this law taking place. In addition, this law also lays down that any publication by a newspaper of an official secret, whether in the form of a note, document, code or password, sketch, plan or model, makes not only the correspondent, reporter, editor, printer and publisher liable to punishment but also every director and officer of the company or corporation with whose knowledge and consent the offense was committed, becomes guilty of the offense. Criticism and demand for repeal. The Official Secrets Act has been widely criticized as being draconian and colonial. Moreover, since the introduction of the Right to Information Act, the Official Secrecy Act has lost much of its relevance. The Press Commissions, 1954 and 1982, the Press Council of India, and several media organizations have time and again demanded the repeal or appropriate amendments in the Act. 2.6 Contempt of Legislature. The concept of privileges of Parliament rests on the principle that a sovereign legislature should be able to perform its legislative and deliberative functions independently and effectively. For this, it should possess certain inherent or conferred powers to punish for breach of such privileges. Articles 105(3) and 194(3) of the Constitution empower Parliament and State legislature respectively to enact laws codifying their privileges. However, neither Parliament nor any of the legislatures of the states has so far done so. Therefore, according to the Constitution itself, the privileges enjoyed by them are the same as those of the British House of Commons on the 26th of January, 1950. Reporting the proceedings of all these houses regularly and daily is the foremost priority for any news organization. Since this task is extremely responsible and rigorous, media persons who are assigned to report these legislative proceedings day in and day out are some of the most seasoned and highly experienced members of the Fourth Estate. As you know, legislatures the world over transact crucial political and legal business to make laws for every single area of the national governance. Hence, accurate, objective, and precise reporting of these proceedings is of utmost importance. Making mistakes or missing out vital points or important details can prove hazardous in many respects, and may even cost jobs, besides incurring legislators' displeasure or leading to parliamentary admonishments and reprimands. 2.6.1 What is contempt of legislature? Breach of privilege of either house of the central or state legislature is usually known as contempt of legislature, like the contempt of courts. While no distinct or clear-cut laws have been enacted so far to precisely describe the contents of contempt of legislature, Article 194(3) of the Indian Constitution enunciates the powers of India's Parliament, and Article 105(3) lays down the privileges of the state legislatures. But, according to D. Basu, though no law with regard to the contempt of legislature has been codified in India, yet such rules and regulations have the sanction of law, being based on judicial decisions, such as the civil law of defamation in India, custom or usage. According to Basu, there is no law yet made by Parliament of India or any state legislature relating to its powers and privileges, even though the Constitution has conferred the power to make such laws. He suggests, therefore, that the journalist in India must roam about amidst the bewildering mass of Indian and English precedents. Though there may be stray enactments relating to the powers and privileges or Procedure appertaining to Parliament, but by and large, the law of Parliament in India is still uncodified. In case of the state legislatures too, the provisions of Article 105(3) of the Constitution apply, which are the same as in case of the Parliament of India. The question arises, what then happens in the event of any case of the contempt of legislature taking place against Parliament or the state legislature? So far, two solutions have been resorted to. A reference is made to the British Parliamentary Practice and Privileges, B. or May's book on Parliamentary Practice is pursued, which is also followed by Britain's lower house, the House of Commons, which is the main source of reference and guide for such purposes. Therefore, it can be stated that members of Parliament and state legislatures in India enjoy all the powers, privileges and immunities available to the members of the British House of Commons. No civil or criminal proceedings can be launched against any member for any statements or speeches made by them on the floor of the House. They enjoy complete freedom of speech and expression in their respective houses. Reporting of proceedings. In this respect, the most important is Article 361A, which was inserted in the Constitution by the Constitution 44th Amendment Act 1978. According to Article 361A of the Constitution of India, no person shall be liable to any proceedings, civil or criminal, in any court, in respect of publication in a newspaper of a substantially true report of any proceedings of either House of Parliament. Article 361A is also applicable for reporting of either houses of the legislature of every state. It is not restricted to newspapers only and applies to broadcast media as well. 2.7 Summary. India is one of the largest democracies in the world, and the mass media in this country constitute a very vital organ of its overall structure. Therefore, to ensure healthy media practices and properly and efficiently serve the people, certain laws have been enacted. These legal enactments are to help and guide you as a media person to function in such a way that you are not caught on the wrong side of your profession, endangering civil or criminal proceedings against you or the media outfits you work for. Keeping this in view, we started with a discussion on the constitutional framework, that means a set of legislative mechanisms meant for media persons to ensure their functioning within the guidelines. Then, we discussed the concept of freedom of speech and expression, laws of libel and defamation, and the journalistic defenses such as fair comment, privilege, truth and justification. For these laws, we analyzed the Official Secrets Act and its relevance in the changing times, especially in the light of the Right to Information Act. Finally, we looked at media responsibility of legislative proceedings and the defenses against contempt of legislatures. It is extremely necessary for you as an aspiring media person to equip yourself with adequate knowledge of such laws. Thank you.